but there's no harm in getting free legal advice about whether or not that decision is challengeable.
With the latest National Pain Report 2025, where Chronic Pain Australia showed that 64% of people living with pain are unable to work. Many are not only left navigating a complex healthcare system, but also other systems like insurance, super, and income protection.
Delayed diagnoses do create problems, but it doesn't mean that if your claim has been rejected for that reason, that we can't sort of seek to overturn it.
Hello everyone, and welcome to today's National Pain Week webinar, proudly sponsored by Maurice Blackburn Lawyers. I'm Nicolette Ellis, Chair of Chronic Pain Australia, and I'm so glad you could join us for this important session. Pain takes opportunity, legal and financial pathways when pain impacts employment. Chronic pain doesn't just affect your health, it can take away your work, income and financial independence. And we revealed this with the latest National Pain Report 2025, where Chronic Pain Australia showed that 64% of people living with pain are unable to work. Many are not only left navigating a complex healthcare system, but also other systems like insurance, super and income protection, often without clear information or support of how to navigate these areas. And that's why we're here today. We're joined by Hayriye Uluca, Principal Lawyer and State Litigation Leader at Maurice Blackburn. Hayriye brings years of experience helping people understand their rights, access the support they're entitled to, even when the system makes it difficult. She'll walk us through key legal pathways, case examples, and practical advice on what to do if pain is affecting your ability to work. After her presentation, we'll put Hayriye in the hot seat and ask her some questions directly from the community.
Thanks so much for having me, Nicolette, and thanks for allowing Maurice Blackburn to participate in National Pain Week. My name's Hayriye. I'm a principal lawyer at Maurice Blackburn, and I specialise in superannuation and insurance. What does that mean? It means that I support people that have prematurely had to stop work due to a medical condition, access entitlements that they otherwise were unaware of, or perhaps they were aware of but had difficulties navigating because of the difficulties that their insurer had presented to them. I want to share a little bit about Maurice Blackburn's story. So Maurice Blackburn started the law firm that we work at in 1919, and the motto that he lived and worked by was that he believed that the law should serve everyone, not just those who could afford it. And it's that genuine and deep belief in access to justice that our staff live and work by each day, and why we offer our clients we offer to act for most of our clients on a no-win, no-fee basis. Who are Maurice Blackburn Lawyers? Well, we're the largest plaintiff litigation law firm in Australia, and we're a values-based firm who have been heavily involved in social change and historic changes and historic cases such as the 40-hour work week, the fight for rights to vote and equal pay for First Nations people and women, the largest class action settlements for Black Saturday bushfires and the Queensland floods, and the illegal sacking of Qantas workers and the waterfront dispute, among many others. I want to share a story with you all about my initial interaction with insurance within super when I first started doing this work about 14 years ago, and why I think it's such an important thing for us to talk about, particularly if you are already affected by a medical condition and are looking to exit employment, or your employment is about to come to an end, or perhaps you've already stopped work a few years ago and you're looking for other ways in which to access some kind of financial support. I acted for a client who, for today's purposes, will be Robert. And Robert came to me after having sustained a medical issue. So he had long-standing diabetes, he'd worked in construction his whole life, and he'd moved from job to job to job. And he'd only ever worked in manual work. One day, 2 weeks into a new job, he walked onto a job site and scraped his leg across a contaminated piece of machinery. And he had a wound that he thought was pretty superficial. Took a bit of time off work, had a work cover claim, and the wound actually didn't heal. Because of his diabetes, he developed a pretty bad infection. That infection got worse and worse. He developed gangrene and he ended up having to have his leg amputated. It was a pretty significant and unexpected outcome for what was seemingly a pretty superficial graze to his leg. And he'd received some work cover benefits. He couldn't sue his employer for negligence because in his circumstances, the employer hadn't done anything wrong. And so he knew those benefits were going to come to an end, and he wasn't financially ready for what was about to happen to him. And he was looking at potentially accessing Centrelink benefits, but he did know that he might have insurance within his super. He called his super fund and they said, yes, well, we've received a late contribution from your employer, but they didn't actually pay your super contributions within that first 2 weeks of employment. And so Robert was quite angry because that meant that he didn't have the insurance that he would have had if the contributions had been paid and the insurance premiums had been deducted from his account to fund insurance for things like total and permanent disability. And I'll talk a bit more about that in this presentation. So he came to me quite angry, wanting to sue his employer for the loss of the opportunity to pursue this lump sum benefit that he thought he'd have through his super fund. We looked at that. Unfortunately, we didn't have a claim against the employer because at that time, and currently actually, if an employer pays your super contributions within 3 months, then they've complied and they essentially they haven't contravened any obligations. But insurance won't necessarily apply for that period. So I said to Robert, look, let's have a look to see if you've got insurance with other super funds that you might have collected over the years. You've told me that you've moved from job to job to job. You didn't consolidate any of your super funds. So let's do a free super check to see maybe if you've got insurance within any other super fund that you might have retained membership with. And so we did that free super check with him. And unbeknownst to him, he actually was still a member of 2 super funds and he had active insurance on those 2 accounts. And we then were able to claim on his behalf over $300,000 of insurance for total and permanent disability. Now, he was quite overwhelmed because he didn't know about this and it had a really significant and positive impact for him from a financial perspective. So what this story really said to me at the time, what this case study really demonstrated to me was 2 key things. One, how important insurance within super is. You don't necessarily have to go out and purchase the insurance. The way that it works is that your employer pays super contributions on your behalf. That's your retirement nest egg. And alongside that, insurance is set up automatically for you for total and permanent disability, sometimes for income protection as well. And you can access that if you apply for it and you qualify for it on medical grounds. So it's a fantastic safety net for people that don't have to go out and actually purchase this insurance, which would be quite expensive if people could only access insurance in that way. The second key thing, though, that it highlighted to me was that the lack of awareness was really quite huge. People just don't know that they have this insurance within super because you're not funding it directly, from your wages or from your bank account. It goes alongside the super contributions that your employer is paying for. It comes out of the account balance. So you don't necessarily notice it. You don't feel it every week or every fortnight when you get paid, but it does get deducted from your super account balance. And so it's an entitlement that people are paying for. It's insurance that people are paying for from their super, but often people are unaware of. And so a big part of the work that we do is spreading awareness about these entitlements and talking to people about ways in which they can access it. So I might then give you a bit of an overview of super insurance and how it all works. And as I mentioned in Robert's case, super disability insurance is gained automatically simply by being a member of a superannuation fund. Your employer pays into a fund and you get automatic insurance for total and permanent disability. It's a lump sum insurance benefit and death cover as well. It's a really effective way for insurance to be given to Australians in an affordable premiums. And we do have a pretty big underinsurance problem in Australia. So it's a fantastic way to insure people who otherwise couldn't go out and get the insurance privately. The way that the insurance works is that the TPD cover is gained automatically because a super fund purchases what's called a group life insurance policy for the benefit of members. And so you automatically become eligible for that insurance when you commence employment, even if you've got pre-existing conditions, provided that as you're working, you're not restricted from carrying out the requirements of your role, or that you've got capacity to work a minimum number of hours per week. So we find people with long-standing, sometimes congenital conditions that they might have been diagnosed with in childhood. They go into the workforce with conditions like MS, like cystic fibrosis, and they might be able to do the inherent requirements of their role for many, many years, but then their condition deteriorates. And I guess people might wonder whether they could claim for pre-existing conditions. Insurance within super is actually one of the best ways to get insurance if you do have that kind of underlying condition, provided that you meet these requirements during the time that you're working. Often you might get benefits for income protection as well. And so 70% of Australian life insurance policies are actually held through superannuation funds. That's about 12 million Australians with insurance through super, but about 25% of people who have this insurance don't even know that they have the cover. That's a significant number of people that are missing out on insurance entitlements that they're paying for, but that they don't know that they can access. And so that's a big part of why it's important to think about these things if you're living with a medical condition or you've already exited employment because you're unable to sustain work because of your medical condition. I want to touch a little bit on some legislative reforms that have come about as a result of the Royal Commission a few years back. And it's really pared back the number of Australians that have this type of automatic insurance through their super. So firstly, there's the Putting Members' Interests First Act, which means that people will no longer get automatic cover for death and disability if their account has not reached $6,000 or more, or it drops to $6,000 or less. So in the example that I gave you with Robert, he'd collected numerous insurances across many accounts over years. Nowadays, if your account balance starts to dwindle and it goes below 6,000 because you've no longer been contributing to it, or your employer has no longer contributed to it for a while, your insurance will cut out automatically at that $6,000 mark. Another change that has really pared back the number of Australians that have this insurance is the Protecting Your Super legislation. So if you don't have an active account for 16 months or more, let's say again, in Robert's case, he had left those previous jobs and it had been more than 16 months since he had had an employer contribute to his super account, that insurance would have ended unless he opted for it to continue. And the rationale behind these legislative changes is that we don't want people's account balances to be eroded by insurance premiums, where that money could be better invested for someone's future. And I think there's debate about whether that's actually good policy, because there's plenty of people that would really benefit, like Robert did back then. I must say that that was the case before these legislative reforms came into play. There'd be people that would benefit from multiple accounts remaining open and multiple insurance policies that they could claim on. But we are seeing that reduce over time because of these legislative changes. I think the best way for us to demonstrate the work that we do and the impact that it has is on real life case studies. And I want to step you through three Maurice Blackburn case studies. And I will say that the pictures that you're seeing and the names have been changed for privacy reasons, but these are based on real clients that we've represented. The first client is Anna, who was unaware of her entitlements through super. So she was a victim of family violence and she was going through a really acrimonious separation with her partner, and a financial counsellor actually supported her finding emergency accommodation. That financial counsellor referred her to Maurice Blackburn in 2019 to see if we could assist her with anything else that they maybe hadn't been able to look over, or we just wanted to make sure that she had been, all potential legal avenues had been investigated. She'd actually stopped work 3 years prior to when she came to us, so back in 2016, and she'd had neck, shoulder and knee injuries following a motor vehicle accident, and she had received some statutory benefits, but she withdrew her account balance in 2018, and no one considered whether she had insurance within super at the date that she stopped work. So her belief was, well, I accessed my account balance, I've drained my account, I didn't leave anything in there, and so I don't have insurance on my account. And that was true at that time, but we were able to do a free super check to see at the time that she was still in employment, when she stopped work in 2016, whether she had active insurance on any super account at that time. And we discovered that she had 2 active super accounts, both of which held insurance at the required time, and she had cover for total and permanent disability, which is lump sum insurance. We made both of those claims on her behalf, and both of those claims were successful. She was paid about $180,000 for one claim and $108,000 for the other. She was really surprised, having not understood that she needed to check insurance at a particular date, having not really known that she was paying for this insurance through her super, and she was relieved because this gave her access to financial stability that she didn't really have otherwise. She was able to secure accommodation for herself and her children and focus on her well-being, which was a great outcome. Another client we represented was Casey, who was aware of her insurance within super, had made a claim, but kind of got lost in the process because the insurer was dragging things out and frustrating the process, and she became overwhelmed. So Casey, a 32-year-old woman, also was experiencing family violence, and it caused a deterioration in her mental health. She developed depression and anxiety, and that stopped her from working as a disability support worker. She made the TPD claim herself, but it was dragged out for years and years by the insurer. So by the time Casey came to us, we looked at the decisions and the process that the insurer had followed, and it seemed that the insurer was seeking to delay the claim on the basis that she had failed to immediately go and seek medical advice for her mental health issues. And that's quite common in mental health claims. People are either focusing on other things, they're trying to secure accommodation, perhaps they're scared to report some of their mental health issues to their doctors if they've got potential custody issues that they might be dealing with their partner, and they don't want mental health to be used against them. Or sometimes people lack insight that what they're struggling with is actually mental health issues, such that they can go and report that to a doctor. And so the delay in seeking that medical advice was used by the insurer to drag out the claim. We took over the claim and made various submissions to the insurer that actually her mental health had manifested at the time that she was still working, and it had caused her to be unable to continue, and we were able to get medical evidence to support that, and her claim was ultimately approved, and she was paid about $160,000 in a TPD benefit. Because of the delay that she'd experienced, we also pursued interest from the insurer for that unreasonable delay, which we received about $20,000, which the client didn't expect. And she was really, really happy with the outcome and relieved again to achieve some financial stability. I think in Casey's case, what was really important for her too was being able to access some private mental health support. She, had exhausted all the Medicare funded treatment. She needed some additional support, but that was just out of her reach financially. And so this money helped her to be able to access that as well, which was great. And lastly, Harry was another client that we represented. He was diagnosed with multiple sclerosis in 2018, and his condition worsened over time. And he continued working, tried to maintain his employment, and he had tried to make an income protection claim through an insurance policy that he'd taken out in 2012. The insurer denied this claim. Now, this is, I should say, a private policy that he purchased himself, thinking that he would protect his financial situation should his condition ever deteriorate to the point that he need to claim. And the insurer denied his claim, citing a GP visit prior to the policy coming into force, saying that he'd reported symptoms that he believed to be an ear infection as grounds to cancel his coverage, alleging that constituted a pre-existing condition. So we challenged the insurer's decision on the basis that he wasn't aware And a reasonable person in his circumstances couldn't be expected to be aware that those symptoms were connected to the later diagnosed MS, and therefore the insurer shouldn't rely on that exclusion to deny the claim. We put in submissions to overturn that decision, and ultimately we were successful, and those income protection benefits were reinstated. So he was really grateful to have income so that he could continue to pay for his living expenses like his mortgage repayments and his groceries. He was relieved that he was able to rely on this expensive policy that he purchased in the event that something happened to him and he was unable to continue working. And of course, just that worry that he had continuously about what he was going to do if the insurer didn't pay was significantly relieved once the claim was approved. Those are three of many case studies that we have had over the years and in different circumstances where people have had a varying degree of knowledge about insurance entitlements that they can access and difficulties that they've had navigating that process and ways that we've helped them to support them to get an outcome. I might touch quickly on the meaning of total and permanent disability, or TPD. Often people ask me, well, what does TPD mean? And what do you need to satisfy to be paid a TPD benefit? Well, the answer that I often have to give is, well, it depends, and it depends on a number of things, including the insurance policy that applies to you at the time. So in some cases, in many cases, you just have to show that it's unlikely ever that you'll return to work within your education, training, and experience. So if you've only ever worked in a particular role requiring a particular skill set, it would be unreasonable for an insurer who has to be held to that particular test to expect you to be going back to something completely outside of your skill set. And it's also about looking at the likelihood, not the actual, with any certainty that you would go back to work or could go back. It's on the balance of probabilities. How likely is it that you'll actually be able to secure employment and maintain that employment in the open labour market? That's the most common test of TPD we see. Over the years, though, what we've seen is that insurers have really tightened up their definitions, their tests for TPD, and made them, incrementally harder and harder. It doesn't mean that it's impossible to meet these tests, but it does mean that we need to be wary about the tests that you might need to meet before we commence the claim. So we've seen insurers move to an unable ever test, which is a much harder test than the unlikely ever test. It's a higher threshold, not impossible to meet, but it will mean that we will need specific medical evidence from doctors to prove that you will be able to satisfy that test and be paid a TPD benefit. Some insurers have introduced a rehabilitation or retraining clause, meaning that, it's not enough to show that you're unlikely to go back to work within your current skill set, but what about if this person was offered retraining or if they were rehabilitated in some way? And the impact of those sorts of definitions is that it does tend to drag out the process because it opens up the realm of possibility to many, many things that the insurer could propose. And I think it is a little bit harder for doctors to sign off on whether or not a person is TPD where that particular definition applies. It's not impossible, but it's important to understand the threshold before you go into the claim. There's also been the introduction of the requirement to be under regular medical care. That might seem, quite a basic requirement, but as I mentioned in one of the case studies, particularly where mental health is an issue, sometimes people do delay seeking medical care. Or there might be, you might have a chronic pain issue that is really hard to diagnose, or where doctors are telling you, look, there's not much we can do. You need to manage this with analgesics and exercise. And so you don't continue to go back to the doctor to complain of things because you're told that you're getting the medical care that you need. And so sometimes insurers might take issue with the regularity of the attendances on doctors. And there's ways around that, but it can add additional hurdles and complexity to the claims. So it's about knowing what you're going into and having the claim prepared before we make the claim on your behalf. And there are other tests like the activities of daily living tests, which thankfully are being phased out, that are extremely difficult to meet. And probably effectively make some of these products junk insurance. I won't go too much into that today, but it's such a difficult test that if you, unless you're extremely unable to move physically, you probably wouldn't meet, and many people don't meet that test. So we are on the back of a lot of advocacy having that particular test phased out of many insurance policies, which is a really good thing for people that are wanting to access these benefits. We've got offices all over Australia, and we also offer a breadth of services outside of super and insurance, including medical negligence, work-related injuries, motor vehicle accident claims, public liability, and faulty product claims. I won't go into those today, but what I do want to leave you with is the message that many people who have been struggling with chronic pain for many, many years, or are hanging on to employment. Some people will have an awareness of insurance that they might have within super, but many people, I suspect, won't know to ask the question. What I would encourage people to do is to seek out information. You can check a benefit statement from your super fund to see what current insurance you have. But you can also seek out a free super check from Maurice Blackburn. We can check to see, based on your employment history, when you stopped work, when your medical issues commenced, what insurance you had at the relevant date, and give you information that will equip you to make decisions about stopping work, or if you've already stopped work, what insurance benefits you might be able to access so that you can secure your financial future. Oh, I might leave it there and open it to you, Nicolette, for any questions.
That was a wonderful presentation, and I certainly learnt a lot in this space. And we receive phone calls via our phone line PainLink, and we have so many people who are unaware of the potential super entitlements that they may have under their super insurance. So I think this is a really strong and helpful message for a lot of people who are living with chronic pain and maybe no longer working, or are thinking about maybe they have to reduce the hours that they work, or leave the workforce altogether. We've got a few questions for you, Hayriye, and we want to put you in the hot seat a bit to understand and unpack these kind of issues. And the case studies were wonderful to sort of understand, the true lived experience of some of these cases, and also the complexity of navigating this. For someone who's currently in the workforce, living with chronic pain, maybe going through trying to get a diagnosis potentially, and those types of things, what would be the first 3 things that someone should do if they're considering that they may not be able to continue in the workplace?
I think, obviously engaging in medical treatment and listening to doctors about the best way to manage their condition is the first thing, first and foremost. And I should say that all the claims that we run are based on the medical evidence and the medical opinions of doctors. So we will frame cases based on the medical situation. So the first thing is listen to your doctors and engage with them about what they think is the right thing to do to manage your condition. I think the other thing too is to understand what entitlements you have through your employer and also through insurance within super. So, there's no harm in checking to see, do I have insurance within super? What insurance do I have? You should have automatic insurance for death and TPD. If you've got a terminal medical condition, you can access the death cover early, provided you've got certificates from 2 doctors specialising in the medical condition, saying that your life expectancy is less than 24 months. So death and TPD are the 2 things that you should have automatically. Income protection you may also have. And so if you're looking to stop work, find out from your employer, like, what sick leave entitlements do I have? Does my employer have an employer-sponsored insurance policy as well as a backup plan? There might be income protection through an employer-sponsored insurance policy that you're not aware of. And separate to that, you might have insurance within super. So I think those 3 things are, medical treatment is the first thing. The second thing is, employment entitlements, and equal second, I would say, is insurance within super. And it might help you to make decisions that you otherwise, wouldn't make, or that you might. I find clients sometimes are forced into a situation where their condition is deteriorating and they're hanging on to employment, and their sort of hours drop off over time. They're working very, very, very little towards the end, but they just feel like they don't have any other financial backup plan. But they didn't know that they had insurance within super. They didn't know they had income protection. And so they sort of almost go against the advice of doctors and cause detriment to themselves. Or in some cases with income protection, the way that they calculate your entitlement is often looking at the last 12 months of your employment and averaging out your earnings to work out what your entitlement will be. So if you hang on to employment and your hours drop off over time, what will happen is you will erode that sort of calculation of pre-disability earnings. And people don't often realise that, and they often say, well, if I'd known earlier on, then maybe I would have been equipped with the information I needed to make a decision that would support my well-being, enable me to live a life that where I can accommodate my condition, but still have that financial backup plan as well. So there's no harm in getting that information early if you're still in the workforce. But equally, if you've already dropped out of the workforce, it's important to sort of get the information and see if you can retrospectively make a claim as well.
And that's a really important point. I had no idea that if you drop your hours, it's makes a change to your claim overall. So I think it's a really essential information that we need to know when we're in the unfortunate circumstance of looking at these leaving the workforce. Another question that I had that sort of comes back from the National Pain Report is we have very significant delays in diagnosis. So on average, about 45% of the respondents to the National Pain Survey took at least 2 years to get a diagnosis. We have at least 10% who still don't have a diagnosis. Does that cause any challenges in accessing insurance claims under your super?
Look, it can, and I think this is the difficulty that we have, particularly if you've got a condition that is really hard to pinpoint and is almost like a diagnosis by exclusion, and it takes years and years to sort of for the penny to drop. I think the problem arises where people just stop engaging in treatment because they feel like they're not getting answers. And then eventually when you make the claim, the insurer will say, well, the condition didn't arise during a period of cover. You've stopped work and your cover has ended and then you got diagnosed. It's not fatal to a claim necessarily if we can get medical evidence to show that actually before this person stopped work, while it wasn't apparent at the time, we can now say with the benefit of hindsight and with, a team of doctors that are now looking after this person that yes, the things that they were dealing with and the impact it was having on their life are the reason why they were unable to continue working. It's better if you've got ongoing access to treatment, if you've got ongoing complaints to doctors while you're working, so that, if asked, a doctor can say, yeah, looking back, I can join the dots, pardon me, and I can see that this was something that was manifesting and had manifested before we were able to land on a diagnosis later. So it's still really important for people to engage in treatment and complain to doctors so there's a record of it. But it does create complexity. And I think that's where getting some support, getting some legal advice about how to navigate those situations is really important. And that's particularly true for those cases where regular medical care is a requirement in the policy. So yeah, unfortunately, delayed diagnoses do create problems. But it doesn't mean that if your claim has been rejected for that reason, that we can't sort of seek to overturn it.
Are there any common myths or misunderstandings that you see about super claims?
Yeah, I think the most common one is I don't want to access my super. I want to leave that for a retirement nest egg. I don't want to touch my super. I think people conflate super account balance with insurance within super. And it's just because there's a lack of awareness that there is that insurance alongside your account balance to begin with. We need to spread the awareness about that and explain the difference. Your account balance remains intact. It's that account balance that funds this insurance, and then you can access your TPD benefit. If you don't want to access your account balance, that's fine. You can leave it intact. You can just take out the lump sum amount, which is the TPD benefit that will be paid into your account balance, and you can leave the rest of it in there. So I think that's one common myth is if I apply for a TPD benefit, then I'm going to drain my account balance. Well, not necessarily. The other common myth is that if I have drained my account balance because I was financially desperate and I didn't see any other option, well, I don't have insurance anymore, so I can't make a claim. So the answer that I always give, it's like having a car accident. It's about, did you have insurance at the relevant time? It doesn't matter if your insurance stopped after the accident, because it's true that if you do access your account balance and you don't leave enough in there to fund premiums, or the account balance becomes inactive because the employer stops contributing for a period of time, your insurance will end automatically unless you opt for it to continue. However, what we do is we check insurance at the relevant date. And if at the time you stopped work because of a medical condition, you had insurance then before the account balance was drained or before the account became inactive, then you should have a claim. And we're often helping people to make these claims for, conditions that caused them to stop work years ago.
And what should someone do if they have had a claim rejected by their insurer, or if their insurer is maybe taking too long to respond? And it seems from your case studies as well, there's a lot of hoops to jump sometimes with the assessments that the insurer might put them through.
Yeah. So I think just because an insurer has denied your claim doesn't mean that that decision is valid. We've experienced many instances where claim has been denied, and then we've gone and made further submissions, or perhaps gone and got further medical evidence, and we've overturned the decision and the claim has been approved. And so I think getting advice about that decision, and we offer no win, no fee agreements. We also offer free advice initially to determine if we can actually provide any support. And if we think the claim doesn't have merit, then we won't offer to act. But there's no harm in getting free legal advice about whether or not that decision is challengeable. You can also make complaints internally to the insurer. So you want to complain about the decision and ask for them to review it. That's called an IDR, or an internal dispute resolution complaint. And they should make a decision on that complaint within 45 days. You can also complain for delay as well. So if you're finding that the insurer isn't giving updates or isn't making a decision in a timely way, or is saying they're going to do something and they don't, then you can make a complaint, again, label it as an IDR complaint, internal dispute resolution complaint, and demand a decision within 45 days. So those are ways you can keep the insurer in check and keep things moving. But certainly no harm in getting legal advice about whether you might need to engage a lawyer to actually take on the insurer and try and get it over the line.
It sounds like you need to keep good documentation on your end as well to if you need to provide that to lawyers, or just to keep your claim valid with the insurer as well.
Exactly. I think having a paper trail, even if you make a phone call to an insurer, having a paper trail and a record of those follow-ups is really important. So
you kind of touched on some legislative changes, which I hadn't been aware of, and around the legal time limits that you have to make a insurance claim. So can you just sort of break that down for us? Can you miss your opportunity if you've waited too long under these new legislative changes?
No. So the legislative changes don't impact, don't create a time limit for you to make a claim. We've got people that, we can go back 10, 15 years. If they had insurance at that time, you can go back and make an insurance claim. So there's no time limit, generally speaking, to put in a claim and seek a review. Where time limits start to become an issue is sometimes if you needed to take your case further, either to an ombudsman or to court, beyond a second rejection of your case. In some instances, depending on the wording of the insurance policy, you might be out of time. In many cases, that's not that's not the case, because the wording of the policy allows us to still dispute the decision further, either through the court process or going to the Ombudsman. But in some limited circumstances, you can be out of time to seek further recourse, either through these alternative avenues. So I think the main thing is, look, just if you know that you've got a medical condition, you were in the workforce, you stopped work, or you were unable to return to work because of your medical condition, no harm in investigating whether you had insurance at that time. You shouldn't be precluded, because it was many, many years ago, from actually putting the claim in or seeking an internal review from the insurer if the claim is denied.
Excellent. And Hayriye, one of our last questions is around the paperwork. How easy is it to make a claim? What would you recommend for people who are starting this at the moment? And what should they be thinking about before making that claim?
Yeah, I think there is a common belief that it is fairly straightforward. And I think, touching back on my very, very brief overview of the different definitions of TPD, every policy will have its own definition of TPD. And even if you're with a particular fund and you say, oh, well, my friend is with the same fund, so we probably have the same kind of claim. Well, no, because the fund will change insurance policies over time, and the insurance policy that applies to you might be very different to the one that applied to your friend. And the test might have become more difficult, or you might have a specific requirement because of your occupation or your employment status. And so I think it's really important to get some advice about, well, firstly, what cover do I have if you don't know what insurance you have? And secondly, what will the claim look like? What challenges will I face? What information will I need to demonstrate? Am I likely to actually get medical support to demonstrate that? So in some instances, it can be straightforward. In other instances, it's actually fraught with complexity that's not obvious on the face of it. And so I would suggest that people engage in legal advice at the outset to sort of really plan the claim. And what we like to do is really front load the claim, knowing what the potential obstacles will be. If we know we need to face these sorts of issues, well, we're going to collate material and put it all together in a way that will give our client the highest chance of success, rather than putting the claim in and then reacting to the problems that the insurer raises. And they tend to do it in piecemeal fashion and drag it out, which is where people sort of get exhausted by the process and just give up. So I would say, if people want to be, on the front foot about it, seek out some support about getting a free super check and having a free initial discussion with our team about what that claim would look like and what we would need to do to enhance the chances of getting it approved.
Wonderful. Well, I want to thank you so much, Hayriye, for spending some time with us today, and your wise wisdom of doing this over your career and helping people with chronic pain. It's obviously a massive issue for our community. We are the leading cause of disability and lost productivity, chronic pain as a condition. And certainly this is a big topic of interest from our community. So I want to thank you very much, and to Maurice Blackburn Lawyers for helping to support this really important conversation.
My pleasure. Thank you so much for having me, and thanks for doing this. I think it's so important. And to be doing it online, where you can reach so many people, is so great. So thank you.
Thank you.